of the Blue Law Group, with offices in Los Angeles and Rancho Cucamonga, California, serving the needs of clients from San Bernardino County to Riverside County to Los Angeles and Orange counties. Today's topic is some of the issues that an employee might encounter with respect to his or her employer during their employment, and some of the things to look out for. First and foremost, a lot of employees don't realize when their employer is violating laws in the state of California. And unfortunately, these employees don't believe that they can be represented by an attorney and either don't know or are too concerned about losing their job, and so they don't bring these issues up, or they don't know about the issues to bring up, or they don't think that they can have legal representation with these issues. So what are some of these issues? Well, first and foremost is breaks. A lot of people are working in companies, and for whatever reason, their employer does not give them a break. Now, under California law, if you're working 3.5 hours or more, you're entitled to a break. And so generally what employers do, to be very careful, is if you're working an 8-hour day, they're entitled, the employee is entitled to a break right generally in the middle of those first 4 hours and those second 4 hours. So after 2 hours, you get a break. And then after 2 more hours, you go to lunch, and after 2 more hours, you get another break. That's the safest way to do it for an employer. But some employers don't do that. So if you're working 4 hours, you're entitled to a break. This is particularly important with things like either hotel or restaurants, where you may only work a 4-hour shift and you don't get a break, because after 4 hours, you go. However, that is a violation of the law. So if you work 4 hours, you are entitled to a break. And for every violation that an employer does with respect to breaching an employee's rights to a break, the employee is entitled to a full hour of their regular pay for every violation of that. Now, lunch. Lunch is similar. A lunch break is also required for anything above 5 hours. So if you are working above 5 hours, you are entitled to at least a 30-minute break. Some employers give 60 minutes, but you're entitled to at least a 30-minute break. And if you work 10 hours, you're entitled to 2 minimum 30-minute breaks. Now, you can waive those. There's certain conditions where you can waive those with agreement with the employer. You could also waive your break under certain conditions, but those are a little bit beyond the scope of this discussion. So, notwithstanding those exceptions, these are rights under the law that you have as an employee. Now, one thing that employees are often not aware of is if you spend money, a business expense, for your job, and you are not reimbursed, that is an absolute violation. Under California law, one of only 2 states in the entire United States, an employer is required to pay you the money that you spent for your job. So say, for example, you have to buy a pen because your boss doesn't have any pens. You buy that pen, your boss has to reimburse you the full cost of that pen. I'll give you another example, and this is an often occurring example. The boss requires you to drive to a park or drive to some meeting place where you have a meeting, and they give you instruction. Well, you have spent gas on that trip, and you are entitled to reimbursement for that gas and the use of your car. Some employers pay 20 cents, 25 cents. That is very likely not enough. The IRS says that you're entitled to about close to 60 cents with their mileage. They don't actually say it's an entitlement. Basically, the IRS mileage is that they won't require you to give them any receipts if you just apply their mileage, their cents per mile. One of the things employers do to be safe is to use that IRS mileage. It's sort of a presumption that there is a payment for the full cost of the use of the car and the use of the gas. But actually, that's a presumption, and it can be beaten. If your car is a type of car that actually the cost is greater than the IRS mileage, you actually have a potential claim against your employer in a court of law for not paying you your full business expense. Generally, though, the employer, to be safe, should give you the IRS mileage. If they're giving you less than that, they're giving you 50 cents or 45 cents. It's close to 60 cents in the year 2015 and 2016. If they're giving you less than that, you should be immediately on notice that you potentially have a claim against them for failing to pay you the full cost of your business expenses that you're incurring on behalf of your employer. Another issue that we'll talk about here just briefly is the fact that sometimes employees want their personnel files. Sometimes they get fired, sometimes they quit, sometimes they are just sick and they want their personnel file. Most employees aren't aware that you have a right to your employee file. Just put it in writing. You may have to pay a small administration fee. You may have to go in and copy it yourself, take pictures, or have a professional do that for you, but you're entitled to go get copies of your personnel file. So keep that in mind. So if you're making that request and your employer is saying no or refusing to give you a copy, or more importantly, making those copies available for you to copy, know that they're very, very likely violating California law, and you potentially have a claim against them. Now, finally, our last topic that we're going to cover today is the difference between an independent contractor and an employee. A lot of times, a business tries to avoid the taxes that go with an employee. Those are Social Security and Medicare taxes, as well as federal and state unemployment taxes that the employer has to pay. A lot of times they want to avoid those taxes. They also have to pay workers' compensation taxes. They also very likely, in many cases, pay additional premiums for negligence insurance, based on how many employees they have. So these are areas where employers are looking at trying to cut to reduce their expenses. And so what they do is they hire you and call you an independent contractor. But in many cases, you're not an independent contractor. You are actually an employee, even though you're called an independent contractor. And that is just a complete violation of the law, where an employer is just trying to skirt the tax liabilities that they're responsible for, shirking those responsibilities, and they are violations of California law. And so keep that in mind. If the control of your work is primarily in the hands of the employer, now there's a lot of elements involved in that, and they go beyond the scope of this discussion. But in essence, if the employer, the employment company, has control over you and your product, if they tell you what time you're supposed to arrive, what time you're supposed to leave, when you can go to lunch, if your desk is on their premises, if it's their computer, if you've got a manager, if you get written up, these are all examples of being an employee. And under California law, it doesn't matter what the employer calls you, an employee or an independent contractor. It's your role. And it is under the analysis of California law that's going to determine whether or not you're an independent contractor or an employee. And if you're an employee, your employer will have substantial violations of law, and they will be having to pay substantial amounts of money in some cases to you and to the government. So, with that in mind, Michael Blue of the Blue Law Group, again with offices in Los Angeles and Rancho Cucamonga, California, serving the needs of clients from the Inland Empire, San Bernardino County to Riverside County to Los Angeles and Orange counties. Thank you.